Thank you. It is 10 a.m. on Tuesday, May 26th, and I would like to call this meeting of the board, this hearing, public hearing of the Board of Zoning Appeals to order. Welcome to the City Council members who also serve as the Board of Zoning Appeals. We have new business, which is consideration of Mrs. Geraldine Jerry Smith's appeal of administrative interpretation of March 11, 2026 by the zoning administrator that the ordinance is an administrative / personal action, and B, that the amendment does not constitute a zoning decision under Georgia law and thus does not implicate the specific procedural requirements under OCGA 36-66-4. And the chair recognizes Mrs. Smith at this time.
Thank you, Madam Chairman, the board. Before we get started on the merits of the appeal, I have filed 2 motions for disqualification. And before I present my case, I have a preliminary procedural motion that must be resolved. I filed a formal motion to recuse the city attorney over a month ago. It is a matter of constitutional due process that this board votes on his conflict of interest before he provides any further legal advice to this board regarding my appeal. My affidavit with supporting documents already filed with my motion provides ample reasons for his conflict in this appeal, as well as being a possible witness in the appeal. He has provided legally incorrect advice regarding House Bill 1405 to pad his billable hours and has threatened me with fees to kill my rights. Because he is a witness and an interested party, he cannot legally advise you. And then the other matter, recusal matter, Chairman, before I present my zoning appeal, I have several. I read that one already. Okay, I filed a motion to recuse the City Attorney Douglas Kidd and a separate motion to recuse board members Tony Allred and Jesse Price. These motions must be considered and this board must vote on them before we proceed. Board members Tony Allred and Jesse Price are sitting in judgment of an appeal that directly challenges the legality of their own appointments to the P&Z Commission. Furthermore, they voted for themselves to secure these positions. Because their appointments to the P&Z Commission is being challenged and under appeal, they cannot legally or neutrally rule in this appeal. I demand that they voluntarily recuse themselves or that the remaining unbiased members of the BOA vote to disqualify them from this specific hearing. So I would ask that that matter be ruled on by the board before we proceed with the.
My recommendations to the council is to proceed and let Ms. Smith give whatever evidence or argument she has as far as her appeal. Her motions are without merit, in my opinion, particularly the motion to try to deprive the council of legal counsel is especially frivolous and without merit. So at this time, Ms. Smith, if you would want to proceed with your case, you can do so.
I would like to ask for a vote by the council on it.
Ms. Smith, this is a public hearing and we are here to hear what you have to say. If you would proceed with your case, we'd appreciate that.
All right, for the record, and to preserve the record on appeal, let the record show that the board is refusing to rule on a timely, properly filed procedural motion on the advice of the very attorney targeted by the motion.
I would note that our second motion was not timely. It was filed this morning, which was not enough time for this board to consider that. So I like that in the records, but proceed this way.
And Madam Chairman, members of the board, my name is Sherry Smith and I'm the appellant in this matter. This is an administrative appeal under our local zoning code. I'm appealing a specific administrative interpretation made by our city manager. The city manager determined that an amendment altering the member qualifications within the text of the Sky Valley zoning ordinance was merely an administrative personnel decision. Based on that interpretation, the city manager determined the town could bypass the mandatory public notice and hearing laws enforced by the state of Georgia. Because of this interpretation, the city council voted on a text amendment without publishing a newspaper notice and without holding a public hearing. Members of the board, local administrative interpretations can never override mandatory state statutes. Under Georgia law, OCGA 3666-3-4B, any amendment to the text of a zoning ordinance is explicitly defined as a legislative zoning decision. The Georgia zoning procedures law makes absolutely no distinction between a map rezoning and a text amendment. Notice and a public hearing are strictly mandatory for both. Because the city manager interpreted state law as optional, the city enacted a text amendment that is legally void from the beginning. To establish this timeline for the record, I'd like to call the city manager to the podium for a brief questioning. Good morning, Mr. Strickland. My first question is, you are the city manager for the city of Sky Valley, Georgia, and you also serve as the zoning administrator of the Sky Valley zoning ordinance. Is that correct? I want to show you petitioner's exhibit 1. And that is Article 18 of the ordinance, and I ask that you look at it and read the title in section 1801.
Provision of this ordinance shall be administered by the city manager. The city manager shall be responsible for interpretation of the provision of these regulations and the maintenance of the official zoning.
So now we have established that you are the zoning administrator and that you are responsible for interpretation of the ordinance. Is that correct? This is petitioner's exhibit number 2. And with that over, that is a copy of the agenda for the City of Sky Valley Council meeting of February the 17th, 2026, that was published by the city on February the 10th, 2026. Would you look that over and read what item 12 is on that agenda?
Consider amendment to the Sky Valley zoning ordinance, first reading and introduction.
If you could hold off a moment, and I have a question for the city attorney, since we do not, as the zoning board of appeals, have copies of any of the exhibits that Ms. Smith is presenting to witnesses.
This is stuff you had presented previously, is that correct?
Yes, and I'm going to
As
present it. I've got copies too to go ahead and enter into the record again today with the clerk.
Yeah, so it should be, or at least the ordinance that she was referring was in the packet.
Thank you.
You can proceed.
And this is petitioner's exhibit 3. The exhibits are just marked different today. They're already in the record, but I'm going to try to keep them separated for this, the official record. Okay, when you look at petitioner's exhibit 3 and state if this is a copy of the item 12, an agenda to amend the city zoning ordinance to address eligibility for appointment to the Planning and Zoning Commission.
This one, this is what was considered signed off and approved by the council.
Okay.
First reading.
Would you read paragraph 3 of the ordinance?
Paragraph 3 or section 3?
Paragraph 3,
The long paragraph?
no, up at the top of whereas.
Oh, okay. Whereas the composition of the Planning and Zoning Commission falls under an administrative personal action and does not constitute a zoning decision under Georgia law and thus does not implicate specific procedural requirements under OCGA 3666-4.
Okay, thank you. And now, this is petitioner's exhibit number 4. And now subsequent to the introduction of the ordinance at the February 17th city council meeting, you received an email from the city attorney Douglas Kidd, along with a public hearing notice for zoning ordinance for Scout Alley. Will you look at petitioner's exhibit 4 and tell me, is that a copy of the email and public notice?
This one.
And would you please read the email?
Jason, here's the public hearing for the P and Z hearing. The kid.
Okay, and then would you please read the public notice he sent to you?
City of Sky Valley Public Hearing, the City Valley, excuse me. Sky Valley City Council conduct a public hearing for the purpose of adopting changes to the qualifications for appointments to the Planning and Zoning Commission. Public hearing will be held on, I think the date is not filled in, 2026 at 10 p.m. at the Sky Valley City Council Chambers at 3608 Highway 246, Sky Valley, Georgia, 30537. Every March.
Now, after you received that public notice, did either you or the city clerk have it published in the Clayton Tribune?
I believe it was, I probably prefer. That was correct. I turned
That's a
that.
no, it was not
That was
published.
great. You want to chime in? Yeah. It was great.
So it was not published in the Clayton Tribune.
It was not.
This is petitioners exhibit 5, and which is a copy of a letter that was sent to you on March 5th, 2026, 2 days after the adoption of the ordinance. Would you look at it and state whether you received it?
It was received by our clerk on the 5th of March, 2026, and that would have been distributed to me after, but it was like the clerk officially received it, but I am aware of this letter.
Okay, would you read that letter to the board?
Email and hand delivery from Jerry Smith, 193 Pleasant Mountain Drive, Sky Valley, Georgia, 30537. Expressed my position as city manager here at City Hall. On request for administrative interpretation of Article 17 or Section 1801 of the Sky Valley's ordinance. Mr. Scrivener, writing to you in your capacity as the official responsible for the administrative interpretation of the city of Sky Valley's ordinance is mandated by Section 1801. I formally requesting a written interpretation regarding procedural requirements for amending the text of the zoning ordinance under Article 17. Specifically, I request your interpretation of whether an amendment to the text of the ordinance is classified as an administrative purpose decision or legislative zone decision. Our request is based on the following provisions. Local procedure, Section 1702, the Sky Valley ordinance, states that procedures for zoning decisions will be governed by the zoning procedures law of the state of Georgia. State definition, OCGA 3636-3. The ZPL defines a zoning decision as a final legislative action resulting in the adoption of an amendment to a zoning ordinance that changes the text of the zoning ordinance. Conflict resolution section 1901. The ordinance dictates that where state statutes require more restrictive standards, those state revisions shall govern. Could you please clarify for the record, you consider a text amendment to be exempt from public notice and hearing requirements of the ZPL? If you maintain that such an amendment is an administrative decision, please provide a specific legal basis for that interpretation, given the definition found in OCGA 36.36.3. I look forward to the response within a reasonable time frame so that I may understand your position and determine the course of action. You signed it. Received on the 5th of March.
Now, did you respond to that letter?
I did, it was forwarded to the city attorney and we had to do what he thought he would do with that.
Okay, now I'm going to hand you petitioner's exhibit 6, which is a copy of a second letter that was sent to you on March 10th, 2026. You look at it and state what you received it.
It was received by the clerk on the 10th of March, and I did get a copy of that, yes, ma'am. And I forwarded it to the city attorney.
Okay, would you please read that letter to the board? Would you like the microphone?
No, ma'am, I'm just coming off laryngitis, I apologize. I was going to know what we're talking about. And delivery email, city manager, March 10th, 26. Mandatory interpretation of Article 15 amendments, deadline for response. The city manager on March 5th, I formally requested administrative interpretation regarding the applicability of the zoning, Georgia zoning procedures law. The text amendment of Article 15 passed on March 3rd. To date, I've received no response. Time is of the essence. Formal zoning verification and administrative interpretation generally require 5 to 7 business day response. Your continued silence is effectively a pocket veto of my right to due process and abuse of discretion through delay. In RV Holdco Inc. versus City of Sandy Springs, 2010, Georgia courts reinforced that administrative officials cannot use unfettered discretion or indefinite delays to block a citizen's rights to a zoning decision. On the written time frame stand established in the city of Tipton versus Smith, a response is effective immediately. I must have your formal written interpretation no later than 12 noon on Friday, March 13th, 2026. As a courtesy and to facilitate an expedited response, I've attached a letter of administrative interpretation form. This document allows you to simply indicate the city position, provide the necessary legal basis for your determination, notice of implied denial. Failure to provide a written response by this deadline will be treated as de facto denial of my request. I will proceed with a formal notice of failure to act in administrative review. I do not receive your interpretation by that time. I strongly urge you to provide this interpretation to prevent the city from knowingly violating ZPL, the Sky Valley zoning ordinance, and state and local ethics codes. And then you've got a letter of administrative interpretation subject to applicability of zoning procedures laws, OCGA 3666, Article 15 text amendment. The yes box, the city of Sky Valley acknowledges that the text amendment, Article 15 constitutes a zoning decision as defined by OCGA. Consequently, the city confirms that all notices and hearing requirements of the Georgia zoning procedure law were or will be strictly followed. No, the city of Sky Valley interprets the amendment. Article 15 is an administrative or regulatory action, does not follow the definition of zoning decision for the ZPL as a place to sign date.
Did you respond to that
I
letter?
did not know that advice to the city attorney that was reported to him.
And this is petitioner's number 7. Is that your response? Is that your response to me on that date?
This was Ms. Smith, good morning. I have forwarded your request to our city attorney, and as my understanding, he will be reaching out to you shortly. Thank you.
So your response to that second letter as well as the first letter was to forward it to the city attorney.
That was direction that was given this time.
All right, now I want you to look at, petitioner's number 2, I believe it was. No, petitioner exhibit 3 again. And on the second page of that ordinance, on the subject order, it shows that on March 3rd, 2026, at a special called meeting of the city council, that ordinance was adopted by the city council with a 4-to-1 vote. Is that accurate?
Yeah, that's what appears in this one.
Right. And was a public hearing for that vote ever published in the Clayton Tribune at least 15 days prior to its adoption by the city council on March 3rd, 2026?
Oh,
Okay, I have no further questions. Thank you. I don't believe I don't have anything else other than my closing statement.
Are there any questions from the council? You may proceed with your closing statement.
Chairman and members of the board, the undisputed evidence and testimony presented today from city manager Jason Streetman established a fatal administrative error that strips this board of any choice but to declare the March 3rd, 2026 ordinance amendment completely null and void. Through the city manager's own testimony, we have established 4 undeniable facts. Number 1, under Article 18 of the city ordinance, the city manager is a sole zoning administrator tasked with interpreting and enforcing the zoning rules. He cannot legally abdicate or delegate that statutory power to the city attorney. Number 2, on February 17th, 2026, the city council introduced a text amendment to change the qualifications for the planning and zoning commission. The city attorney immediately sent the city manager a mandatory public hearing notice to publish. The city attorney knew a hearing was legally required under Georgia zoning procedures law. Number 3, despite receiving that explicit notice, the city manager and city clerk failed to publish it in the Clayton Tribune. On March 3rd, 2026, just 2 weeks later, the council rushed through a 4-to-1 vote to adopt the ordinance at a special call meeting with absolutely 0 public notice and 0 public hearing. The city manager was warned in writing on March 5th and March 10th that this vote violated the strict 15 to 45 day notice mandates of OCGA 3666-4. Instead of correcting his administrative error, his March 11th email proves he completely abandoned his duties as zoning administrator and abdicated his legal duties and oath of office. By failing to advertise the hearing, ignoring the city's attorney's written directive to publish, evidently relying on his decision and his own interpretive duties that the amendment was an administrative personnel decision and did not institute a zoning decision under Georgia law and thus does not implicate the specific procedural requirements under OCGA 3666-4. The city manager did not only make a serious administrative error, he actively violated his oath of office by not publishing the public notice. Members of the board, you also took an oath to uphold the law. You cannot honor your own oath if you vote to validate a clear violation of his. I respectfully ask that you uphold the integrity of Sky Valley's charter and its zoning ordinance and the laws of the state of Georgia. Recognize this total administrative failure that resulted and the city council adopting this amendment in violation of the law, and therefore declare the March 3rd ordinance amendment completely null and void. I'm not going to restate all of the case law I have already filed into the record. The city has had it for months with ample time to review. That case law clearly establishes that under long-standing Georgia Supreme Court precedent, strict compliance with the ZPL is mandatory. If a city fails to publish notice between 15 and 45 days before adopting a zoning amendment, the amendment is legally non-existent. It is void from inception. The city manager committed a clear administrative error by failing to advertise, failing to hold a hearing, and his failing to independently interpret the zoning ordinance. I respectfully request that this board uphold it so, recognize this administrative failure, and declare the March 3rd ordinance amendment null, void, and of no legal effect. Thank you.
Council, I would just like to say something briefly, just to have it on the record. Actually, a lot of this is out of order and also wrong. I think Ms. Smith is trying to play up Jason Street and never responded to her.
Madam Mayor, I would object to the city attorney testifying if he wants to address or going to oath and testify, but I think he's testifying about his conversations with Mr. Streetman.
Actually, I'll just say this. All of her concerns were addressed to her in an email that I sent to Ms. Smith on March 13th. I sent 2 very long legal memos explaining the city's position on why it was not a zoning decision under the law and why the Zoning Procedures Act did not require us to have a public hearing. She's neglected to talk about that at all. I've copied y'all on that. Y'all seen those memos that I've sent. She's not addressed those at all because she knows that the legal arguments raised in those memos trump whatever understanding that she may have of the zoning procedures law. More interestingly, there's a case directly on point called Greater Atlanta Home Builders versus DeKalb County, which she never addresses. And I'm just going to read a little bit of language on that. And this goes to whether what we did is considered a zoning decision under the law, which would require us to have a public hearing or not. But the quote is, whether a local regulation is a zoning ordinance subject to the zoning procedure law is determined by evaluating the regulation as a whole to determine whether or not it involves dividing a governmental unit into zones or districts and applying different standards to such zones or districts in regard to property therein. You only have to have notice in the paper, as she's saying, if it is a zoning regulation dealing with someone's use of their property or putting property into zoning districts. That makes it a zoning decision. The ordinance that she's complaining about was the one where y'all decided whether you could have a part-time person sitting on the committee. That does not deal with someone's real property. It does not put property into zoning districts. The Greater Atlanta Home Builders case is directly on point. She's never addressed it. She just skims right over it because she does not have any other case law that can combat it. Until she comes has some argument for the Greater Atlanta Home Builders, you know, I really just don't want to take her argument too seriously. We were here today because she's filed her notice and we're giving her due process and we let her present her case as she sees fit. But just, and I will resubmit those memos that I've sent to y'all previously about why this is not a zoning decision. But y'all can make whatever decision that you want to make. Under our ordinance, we have to have a reasonable time period to give her a decision. I would say that would be 30 days would be a reasonable time period to give her a written decision based on this today. Unless y'all have any other questions for me or for her, then y'all can go ahead and adjourn the meeting.
And in response to that, I did indeed respond to Mr. Kidd's and rebutted and to rebut a memorandum against the incompatibility of offices on the 2 members that were appointed to the planning commission. And also in regards to the cases that he cited, I sent them to him originally, and then when he never responded back to me on anything, I made an offer and compromise after that, which he ignored. So then I sent those to the council about a week later to inform y'all what was going on between me and the city attorney. And y'all have those in the record, so when you're considering what he's considering, I also ask that you look at my rebuttal to him on those laws that he made. Also my memorandum, there's two separate documents.
Thank you, Ms. Smith. Thank you all. We will take this under advisement and as our city attorney says, a reasonable amount of time would be 30 days. So if that is acceptable to the Board of Zoning Appeals,
I have a question.
Yeah.
What happens in those 30 days? Is there a vote taken? And then that vote is published? Tell me how the decision of this board becomes known to Ms. Smith.
It is not listed in the ordinance how exactly y'all are to deliberate, but I think that if y'all wanted to I think if someone wanted to draft a draft order on what they think that it should be and submit it, and then y'all can have what, add or delete anything that you want to that draft order until you get something that you agree on, and then you can vote on it to issue it as the official order of the Board of Zoning Appeals.
And when and how do we vote on it?
You can have it at the next council meeting.
So 30 days would be the June council meeting
Or I
because
guess it would be.
July would be past the 30 days. I'm just trying to clarify the
It says a
response
rea-
to Ms. Smith.
It says a reasonable time period, so I mean, if it ends up being 35 days or something, I don't think that's unreasonable, until we can come back and vote on it at the July meeting.
The July meeting is when she can expect her answer.
When is the June meeting? When is the July?
16th is June, July is 21st, I believe, Sharon.
I think we could probably have it by the June meeting, so less than 30 days.
June 16th,
Yeah, I think
she can
that's-
expect her reply,
I think that's fair.
and then we will vote on it at that meeting to give her her response.
That's right, yes.
any further questions? So,
A motion to adjourn.
there is another, in other business, and in fact, number 3 on this is public comments and public forum and general comments. So I believe we need to follow the agenda on that. And if there is any public comment from the audience in the room, any general comments from anybody on the Zoom call? We would welcome them now. The chair would recognize you. And there being no comments in the public forum or general comments section of this agenda, and there being no other business, I will entertain a motion to adjourn.
A motion to adjourn.
Is there a second?
Second.
Thank you. Any discussion? All in favor?
Aye.
Aye. Any opposed? Thank you. This meeting is adjourned. Thank you, Ms.